We're really delighted to continue the discussion started with by the Deputy Attorney General Lisa Monaco yesterday, and Matt Olson, and everyone. And by the way, I really want to thank everyone from all the government agencies who are here. We really were very lucky to have almost every single major government agency that all of you deal with, from Commerce, Treasury, Civil Division, Criminal Division, Antitrust Division. So I want to thank all of them for really coming here and participating. It makes it a completely different experience. So I'm really delighted to, and I don't think he needs a major introduction because we've introduced him several times before and everybody knows him. We're really delighted to have with us the Assistant Attorney General for the Criminal Division, who's had a long and illustrious experience, even though he's still a baby, Kenneth Polite.
Good morning. Good morning. I hope everyone's awake. Long nights. Thanks again to my dear friend and former AG, Alice Fisher, for the invitation for joining us here again at this esteemed event. Of course, last year we had the great fortune of gathering together in San Francisco. And for many of us, that was the first large conference that we had an opportunity to attend since the COVID pandemic upended our lives. And so in so many ways, last year gave us the opportunity to celebrate as members of the White Collar Bar. But if you recall last year, and if you took the opportunity to walk outside the cozy confines of our hotel, you might have seen a very different world. You may have experienced a very different sense of community, because in the middle of a city that has some of the country's most expensive real estate sits a neighborhood where poverty in its full humility and humanity is readily apparent. You see, during a very short afternoon walk between that hotel and our U.S. Attorney's Office, we saw homelessness and drug addiction and food insecurity, lack of hygiene, violence, human suffering. And we see it in every city in which this conference gathers, be it in the Tenderloin area of San Francisco, or Liberty City here in Miami, or the Lower Ninth Ward in my hometown of New Orleans. The same things that could be found in every town across this country, and indeed across this globe. Right outside, right around us, right around you, if you decide to open your eyes and accept a broader concept of community. I bristle at times about the label of being a prosecutor, not because I don't hold prosecutors in high esteem, no. For many of us that have had the job, I see it as one of the first and most noble roles in our profession, but that moniker does not fully capture the breadth of our capabilities or the depth of our human capacity. No, instead, I borrow from our former assistant, our former AG, our former Attorney General Eric Holder, that we are better described as community problem solvers, people who are able to marshal a variety of tools to creatively address the challenges before us. One of those tools is, of course, criminal prosecutions. In that regard, the Criminal Division had a banner year in tackling white-collar crime. Since the beginning of 2022, our prosecutors entered 8 corporate resolutions, as well as 2 corporate enforcement policy declinations. Our money laundering and asset recovery section convicted more than 24 culpable individuals. Our fraud section charged 280 individuals and convicted over 340. But our successes cannot be measured solely by statistics. No, our ability to make change in the community requires that we bring the right cases, the righteous cases. To that end, allow me to lift up the department's work right here in this district, the result of great collaboration between our FCPA unit and the U.S. Attorney's Office here in the Southern District of Florida, the successful prosecution of the former National Treasurer of Venezuela, Claudia Patricia Diaz-Guillen, and her husband, stands as one of those righteous cases. Now, as you all know, Venezuela has been suffering from acute crises, including rampant inflation, chronic fuel shortages. According to one study by researchers based in Caracas in 2019, 96% of Venezuelans lived in poverty. But not all did. Diaz, together with her husband, accepted over $100 million in bribes from a Venezuelan billionaire to obtain access to purchase bonds from the National Treasury at a favorable exchange rate. All the while, millions of Venezuelans had to confront daily economic crisis, rampant inflation, unimaginable poverty, and hunger. And so last December, after a 3-week trial, a jury convicted both Diaz and her husband of money laundering offenses. They both now face lengthy prison terms, and we are seeking over $130 million in forfeiture, a righteous case that spanned the globe to hold multiple corrupt actors accountable and remove corrupt leadership. This prosecution exemplifies what our prosecutors are capable of. Span the globe. Yes, I said spanned the globe, because to be truly effective community problem solvers, we must broaden our sense of community. Crime does not limit itself by country or by region. Corruption's corrosive effects are global, with the world's poor often bearing the brunt. Bribery threatens our collective security by undermining the rule of law and providing a breeding ground for other crime and authoritarian rule. So just as crime recognizes no borders, our efforts to combat it must be equally boundless. We need our partners, both domestically and internationally, to help solve community problems. Fortunately, this is where the criminal division thrives best. The Diaz case I just referenced involved cooperation from our various international partners in several aspects, including extradition. Likewise, the recent Glencore and ABB and Danska and Stericycle corporate resolutions, among many others, underscore the successes that we've shared with our colleagues abroad. This international cooperation has also been critical to MLARS's work on the Kleptocracy Asset Recovery Initiative, which has targeted and restrained more than $3.6 billion relating to foreign official corruption and associated money laundering affecting our U.S. financial system. In fact, you've heard about our Bank Integrity Unit. It has long recognized the central role our financial system plays in the global community and the gatekeeping role that financial institutions serve. Sanctioned actors around the world seek to exploit the U.S. financial system, in some instances working with global financial institutions that help facilitate their crimes. But you see, if you want access to our U.S. financial system, or you provide access to that system, you must play by the rules or else face the consequences. Our BIU makes sure that you face those consequences. In fact, since 2010, the BIU, with just 12 attorneys, has imposed more than $13 billion in financial penalties and 10 corporate criminal resolutions with global financial institutions for sanctions violations. I am heartened by our Deputy Attorney General's announcement yesterday of additional resources for this all-important unit, as well as her focus on the intersection of national security and corporate prosecution. I know that our BIU attorneys will build upon their outstanding track record while continuing to work shoulder to shoulder with our partners in the National Security Division to achieve our united division. But you see, there is no better way to broaden our sense of community than to speak your partner's language, literally. You see, starting over a decade ago, our FCPA unit, together with our partners at the SEC, have released the FCPA Resource Guide to provide helpful information to the public, including practitioners and enterprises of all shapes and sizes. And I'm pleased to announce that thanks to our fraud section's work with our OPDAT section, we will reissue the FCPA Resource Guide in Spanish later this month. This is a concrete example of how we are expanding our concept of community, how we stand with our partners in our collective fight against global corruption. Now, I acknowledge that with an expanded sense of community, problems can become tougher to solve. But you see, no matter how difficult they may be, we do not shy away from those challenges. It is indeed our duty and our honor to run towards them. And tougher problems require creative solutions. That is why our prosecutors do not just wait for cases to come to us. No, instead, we detect wrongdoing through proactive and sophisticated methods of identifying criminal wrongdoing, including groundbreaking data analytics. Our fraud section's healthcare fraud unit has long led the way in this regard. You see, from the inception of the very first healthcare strike force right here in Miami, the strike forces have used data to proactively identify, investigate, and prosecute the most egregious fraudsters. And you see, when the pandemic hit, it was the healthcare fraud unit that convened an interagency working group of law enforcement and public health agencies. Again, a broad community to bring a whole of government approach to data analysis that delivered results. Those results, by one representative example, in the very first COVID-19 related healthcare fraud and securities fraud case to go to trial, a Silicon Valley technology company president was convicted at trial on all counts, one of the record 38 trial convictions by the healthcare fraud unit last year. Or you can take our fraud section's market integrity and major frauds unit. You see, we have worked with data analysts and scientists to develop algorithms that help us detect leads that are indicative of fraud and manipulation in the securities or commodities or cryptocurrency markets. And by assessing those trading data and that SEC filing information, our experts detected company insiders who greatly outperformed the market when trading pursuant to 10b5-1 plans. Plans which, as you all know, allow insiders, when they are not in possession of material, non-public information, to set up pre-planned stock transactions. It was their proactive analysis and their subsequent investigation that led to the arrest this week of Taryn Pizer, the founder and CEO of OnTrack, a publicly traded company for insider trading. Pfizer allegedly entered into 2 of these plans while in possession of inside information about a significant risk that OnTrack's then largest customer was going to end its contract with OnTrack, or at the very least renegotiate its terms. And when this came to pass, OnTrack's stock lost more than 44% of its value. But because Pfizer had previously entered into a 10b5-1 plan, while in possession of that inside information, he was allegedly able to sell more than 600,000 shares and avoid losses of more than $12.5 million. This case marks the department's first ever insider trading charges based on activity conducted exclusively pursuant to a 10b5-1 plan. In some respects, this is a classic insider trading case. It's a high-level executive who allegedly cheated the market by trading on inside information. But this case is indeed remarkable for what it says about our prosecutors' creative problem solving. Over the last 2 years, through their ingenuity, through their grit, through their creativity, our team identified this defendant who allegedly tried to use the cloak of a 10b5-1 plan as cover for his criminal conduct. Take note, because I certainly expect other similar cases will follow. Our creative enforcement efforts also apply to those who abuse cryptocurrency and digital assets. Last year, our fraud section and its partners charged 9 defendants for cryptocurrency fraud-related offenses and spearheaded a nationwide crypto fraud enforcement action. And just last week, this team charged the founders of Forsage, a decentralized finance cryptocurrency investment platform, for their roles in an alleged global Ponzi and pyramid scheme that raised approximately $340 million from victim investors. Their work is complemented by our National Cryptocurrency Enforcement Team, which in January announced its first public enforcement action, together with our partners from the Eastern District of New York and abroad. That action, the international coordinated takedown of BitsLotto, a cryptocurrency exchange, including the arrest of its founder right here in Miami for operating an unlawful money transmitting business. Now, community problem solving. It requires more than just prosecuting crime after it happens. To truly help solve a problem is to prevent it from occurring in the first place, which of course is our ultimate goal in our fight against crime. That is why we continually refine our policies to help incentivize ethical behavior, providing transparency for the public, for the business community, for counsel as to what we expect and what will happen when our expectations are not met. In January, as many of you know, I announced the first substantial revisions to the Criminal Division's corporate enforcement policies in 5 years. This policy provides certain incentives, including a presumption of a declination, and even if a company doesn't receive a declination, the possibility of reduced financial penalties of up to 75% off of the sentencing guidelines fine range for companies that voluntarily self-disclose misconduct and fully cooperate with our investigations and timely and appropriately remediate. You see, companies that self-report their misconduct set the right tone for their employees and lead by example, showing them through actions, not just through words, that criminal conduct will not be tolerated in their workplace and will be reported to the authorities. Those are the companies that walk the walk when it comes to culture and tone at the top. Remember, the potential benefits under our CEP only flow from being a good corporate citizen. The consequences will be far more severe for those companies that sit back and wait for us to come knocking. There is an enormous gulf between the benefits associated with doing the right thing and the punishments associated with not. To that end, I give you Exhibit A. Because after a company enters a corporate resolution with us, those same rules apply with even greater force. Yesterday's announced resolution with Ericsson makes that point clearly. You've heard us message this over and over again. Entering a resolution is in many ways not the end, but the start of a new path with a focus on cooperation and a focus on compliance. And we are all collectively committed to the follow-through and holding companies to the letter of those agreements. What did Ericsson do? It breached its 2019 deferred prosecution agreement by repeatedly failing to live up to its obligations. The company failed to timely disclose requested and highly relevant documents, prejudicing the government's ability to charge certain individuals. And it failed to fully and timely disclose information related to extremely problematic conduct in Iraq. The result today is that the company has agreed to plead guilty to the 2 original charges in connection with that DPA. The company has agreed to pay an additional $200 million in penalty, including the elimination of the benefit of cooperation originally received under our CEP. Their monitorship has been extended for an additional year. Our resolve is clear in this area. A company's good behavior will be met with benefits, but the failure to live up to those obligations will be met with severe consequences. When we see criminality across our globe, we will not just ask what happened. No, we want to understand the root causes. Why did it happen? Will it happen again? That is what distinguishes a community problem solver from someone who simply files criminal charges. And that is why the presence or the absence of a functioning compliance program at both the time of the misconduct and at the time of the resolution is absolutely critical to our decision-making in corporate matters. As you all know, to make expectations clear to the public and to companies, our prosecutors apply the publicly available criteria set forth in the Evaluation of Corporate Compliance Programs, or the ECCP. Because a corporate compliance program must be evaluated in the specific context of a criminal investigation, we do not use one formula to assess the effectiveness of a corporate compliance program. We disavow any box-checking exercise, and we recognize instead that each company's risk profile and solutions must be particularized in that evaluation. Now, with that said, there are some common questions that we may ask to make that individualized determination. Today, following up on our DAG's direction in her September 15th, 2022 memorandum, I'm announcing several changes to that ECCP, including how we consider a corporation's approach to the use of personal devices, as well as various communications platforms and messaging applications, including those offering ephemeral messaging. You see, in today's day and age, the use of these services is ubiquitous. So just as we ask you, as we expect corporations to adapt to the realities and the risk of modern life and update their policies and practices accordingly, so too does the department. Under the revised ECCP, we will consider how policies governing these messaging applications should be tailored to the corporation's risk profile and specific business needs, and ensure that, as appropriate, business-related electronic data and communications can be preserved and accessed. Our prosecutors will also consider how companies communicate those policies to their employees and whether they are enforcing those policies on a consistent basis. We will ask about the electronic communication channels used by the business, as well as their preservation and deletion settings. And we'll ask about any bring your own device programs and associated preservation policies. But we won't stop there. During the investigation, if a company has not produced communications from those third-party messaging applications, our prosecutors will not accept that representation purely at face value. No, they will ask questions. They will ask about the company's ability to access such communications, whether they are stored on corporate devices or servers, as well as applicable privacy and local laws, among other things. A company's answers, or the lack of answers, may very well affect the offer it receives to resolve criminal liability. And we push more. We push more because, again, the highest priority that we have, and yet one of the most pressing challenges that we face in investigating and prosecuting white-collar cases, is ensuring individual accountability. As our Deputy Attorney General announced yesterday, the Criminal Division has updated its policies concerning corporate compensation systems, compensation structures that clearly and effectively impose financial penalties for misconduct, can deter risky behavior and foster a culture of compliance. And at the same time, you see positive incentives such as promotions and rewards and bonuses for improving and developing a compliance program or demonstrating ethical leadership. Those positive incentives can help drive a culture of compliance. So with those principles in mind, we have made a few significant changes. First, our prosecutors will now consider more closely compensation structures and consequence management when evaluating compliance programs under the revised ECCP. They will consider numerous factors to determine how a company's compensation system contributes to the presence or lack of an effective compliance program. Now, let me be clear here. While we have made significant revisions to the ECCP about clawbacks and the use of personal devices and other communication platforms, our criminal division has already been focused on these issues. These ECCP revisions serve to recognize their importance and provide additional transparency about how our prosecutors will consider them going forward. But these remain only two facets of corporate compliance programs that we will be assessing. We will continue to ask questions about, for instance, how companies follow up on their hotline complaints or learn from the issues that they encounter from those calls. And secondly, in addition to those ECCP changes, the Criminal Division is launching a pilot program. One, to require as part of a criminal resolution that corporate compliance programs must include compensation-related criteria. and 2, to offer fine reductions for companies that seek to claw back compensation in appropriate cases. In requiring new compliance-related criteria, our prosecutors will use their discretion to craft appropriate requirements based on the particular facts and circumstances, including applicable law. Our goal is to ensure that the company uses compliance-related criteria to reward ethical behavior and to punish and deter misconduct. Now, as to clawbacks specifically, for companies that fully cooperate with our investigation and timely and appropriately remediate that misconduct, they may receive an additional fine reduction if the company has implemented a program to recoup compensation and, in fact, attempts to use that program. We expect companies that use these programs to address not only employees who engaged in wrongdoing in connection with the conduct under investigation, but also those who had supervisory authority over the employees or the business area engaged in the misconduct and knew of or were willfully blind to the misconduct in the first instance. Now, if a company meets those factors and in good faith has initiated the process to recover such compensation at the time of that resolution, our prosecutors will accord an additional fine reduction equal to the amount of any compensation that is recouped within the resolution term. That is the new pilot initiative. And we recognize the difficulties companies may face when attempting to claw back compensation. That is why if a company's good faith effort is unsuccessful by the time the resolution term ends, our prosecutors will have discretion to accord a fine reduction of up to 25% of the amount of compensation that has been sought. Our division has previously recognized companies for taking appropriate action as to a culpable employee's compensation. In fact, in December, as part of a CEP declination issued to Safran, we specifically noted that the company's timely and full remediation included the withholding of deferred compensation of a former employee involved in the underlying misconduct. We are not trying to incentivize waste here, folks. To the contrary, companies should make an assessment about the potential cost to shareholders, the prospects of success of clawback litigation, given any applicable laws, and weigh it against the value of recoupment, and then proceed in accordance with their stated corporate policies on executive compensation. This pilot initiative will be in effect for 3 years. It will allow us to gather data and assess its effectiveness, and also aid other components and other offices in considering decisions in this very important area. But for now, this is yet another example of the Criminal Division's ability to incentivize good corporate citizenship and encourage greater individual accountability, which again remains our #1 priority. As the Deputy Attorney General also announced yesterday, we are also issuing a revised memo on the selection of monitors in the Criminal Division itself. This revised memo builds on one previously issued by my good friend, former Assistant Attorney General Brian Benczkowski, and today's memorandum makes clear to the public, to our prosecutors, to defense counsel and corporations, how we select monitors for our matters. It also articulates and clarifies the conflict of interest obligations associated with serving as a lead monitor or even as part of a monitor team. But let me lift up one particular provision in this memo, which shows the reach of our community, the reach of our efforts. Today's announcement makes explicit what has been the case for the last few years, that any submission of a monitor candidate by a company and the selection of monitor candidates by the criminal division should be made in keeping with the department's commitment to diversity, equity, and inclusion. We have required this commitment as part of our resolutions, and we will continue to do so, because to improve and expand our sense of community, all of its members should be, and indeed must be, fully represented. All of this work, our past successes, our recent enforcement actions, our policy improvements, all of these efforts help us solve problems in our community. Now, there may be some, indeed there may be some amongst you who question why the department is announcing so much policy in this space. Does all of this have to happen now? My response is that there is no better time than right now. Are we to shy away from the problems posed by the increased use of new ways to communicate in our personal and professional lives? No. Are we to ignore the problems posed by companies that fail to recognize the clear connection between compensation and compliance? No. Are we to run away from the problems posed by the glaring lack of diversity across our profession? No, no. Now is the time for the department to step forward to solve these long existing problems. Doing so right now may lead a company today to start considering revisions to its compliance policies. Doing so right now may empower a whistleblower to call that hotline and report alleged wrongdoing. Doing so right now may give voice to a compliance professional to better advocate for critical resources. Doing so right now may result in that individual employee making the right rather than the wrong ethical decision in that workplace. Embrace that urgency. Not just our prosecutors, but defense counsel and in-house professionals, all gathered here. Use that urgency to help solve the problems that you see. Act in a way that is meaningful, that sets the right tone, that leads by example. Craft and implement effective compliance programs that help us detect misconduct. Push to create a culture of compliance. Push to empower ethical decision-making by our employees. And beyond that, there is so much work to be done, because I fundamentally believe that you are not just the best of our practice or the best of our profession, you are the very best of our world community. Imagine for a moment if only a small fraction of the group assembled here, instead of focusing, as we do over and over again at this conference, on the end results of criminality, but instead we engaged more at the root causes and became more proactive to prevent it in the very first place. That is a task. That is a task that cannot be accomplished from behind a desk or from the cozy confines of a posh hotel. No, it requires us to step outside of our offices and step outside of our homes and embrace a broader sense of community and engage our brothers and sisters on the challenges facing us all. Let us solve our community's problems together. That, ladies and gentlemen, is our calling. That's our calling today and every day. I thank you for your time.